Brian. Bill, are we good to go? Good to go live? All right, Brian, good to go live? Okay. All right. Welcome, everyone. Thank you so much for being here. My name is Christophe Courchain. I'm the director of the Environmental Law Center and the director of the Environmental Advocacy Clinic here, Vermont Law and Graduate School. For those here in person and for those joining online, every year here at VLGS, we honor an inspiring environmental leader at our commencement weekend with an honorary degree and invite them to give remarks the day before today. So this is true to our role as one of the nation's leading law schools for environmental law. Over the last year, I have led the Environmental Law Center, and next year, I'll be leading both our environmental law programs and our experiential programs in the law school. I'm especially honored to do so because these are longstanding and signature strengths of this very special place. It's a great privilege, a bit daunting, but I will do my best. Students come from around the country and the world, whether in person or online, to take advantage of our incredible environmental law curriculum, which includes dozens of law and policy courses across a wide array of environmental topics, from climate change to environmental justice, to food and agriculture, to animal welfare, to the clean energy transition, to international environmental law, and more. We have experiential offerings in all of these areas, enabling students to hit the ground running in their passion to become catalysts for the many changes we need to build a just society. And there is no greater need than addressing the climate crisis. Today, I could not be more delighted to introduce to you all our honorary degree recipient this year, Julia Olson. Julia is the co-executive director and chief legal counsel of our Children's Trust, a nonprofit law firm she founded in 2010 to empower young people to secure their climate rights, protect their futures, and save our planet. Julia received her law degree from what is now the University of California College of the Law, San Francisco, and her BA from the University of Colorado. She has a long list of litigation accomplishments across the country as she has led her team and indeed a movement for recognizing society's constitutional obligations to this and future generations of young people. In my own clinic, I have worked with students learning from the Our Children's Trust litigation strategies, and I have watched as those students take deep inspiration from this work. Before welcoming Julia up here, I wanted to highlight 4 reasons why I think we should admire her as an advocate and what she has achieved so far through the Our Children's Trust cases, and you'll see why it is an incredible honor for her to be here with us today. First, the children's climate constitutional rights litigation work that Julia has pioneered is one of the best examples of how legal scholarship, the things that a lot of our law professors at places like this do every day, can drive the law in new, innovative directions. Julia's work flows from a body of scholarship by Professor Mary Wood at the University of Oregon, who has argued that there is a constitutional right to a stable and safe climate, as it is a predicate to the enjoyment of all our other constitutional rights. And also that the government holds our atmosphere in the public trust, meaning that we have the legal right to hold the government accountable for failing to protect it. This is the starting point for Julia's work, and it powerfully shows how bold, creative work that takes place in the legal academy can contribute to path-breaking legal work in the real world, as it certainly has here. Second, our Children's Trust is an organization that takes its clients seriously and fights for their interests with dogged determination. Our young people, our Children's Trust clients, deserve a safe future. The idea that this is a legally enforceable right should not be controversial, but it is. For Julia, it has always been about the amazing young people she is representing. This is living the lawyer's credo to zealously represent your client. Third, our Children's Trust takes climate science seriously. So few of those in power do this, even though there is a lot of lip service in some circles to it. The climate crisis is upon us, however, and we have the tools we need to achieve a safe and stable climate system. Our Children's Trust cases unflinchingly present the evidence and how the impacts of climate change are going to be devastating for our children's generation unless we take dramatic action now. That is what the science says. And so they ask for that dramatic action, unashamed of doing so. Fourth, our Children's Trust has been fearless in the face of pushback. This is so key, especially this year today. And it harkens back to how fearless the leaders of our broader civil rights movement are. So many doubters, so many critics from the sidelines have questioned their work. There is a tendency among risk-averse legal folks to go along to get along, to trim their sails, to tailor their arguments in ways that undermine the imperatives that drive the cases in the first place. Not our Children's Trust. Julia's team has fought doggedly with a hostile judiciary and completely unscrupulous government defendants who have used every legal tool in the toolbox and more to deny our Children's Trust access to the courts to press their case. While Julia's team has sometimes lost motions and cases, that does not mean they have lost the fight. Indeed, as I'm sure Julia will talk about, they have moved the needle against incredible odds. My oldest son turns 18 today. Hello out there, Malcolm. And it gives me such a huge thrill to have Julia, one of our generation's premier fighters, for my son and so many other kids across the world, here with us, and to celebrate her with an honorary degree. Please join me in welcoming to the podium Julia Olson.
All right. Wow. Thank you, Christoph. That was amazing. I want to thank the entire Vermont Law and Graduate School community for having me here and awarding me with this degree. I want to thank Sue, wherever you are, Folger, for making my visit here so smooth and easy. Thank you for everything you've done. So there's some really important people who teach or have taught at this school. And it's one reason why I'm so honored to be here and to receive this degree. One person who's no longer with us here on Earth is Jack Tucholsky. And Jack Tucholsky hails from Montana and actually helped us in some early phases of our Held versus Montana case that I'll talk about today. He was a visiting professor here and just an incredible human. And Pat Prento, you have given me hell all along the way.
That's what I do.
I know, baby. But really, you know, people like Pat challenge the theory, challenge our strategic choices, and it's really helpful as a lawyer to have people push back and help you think critically about what you're doing. And then Gus Speth. So we could not have done what we did in another case that some of you may know called Juliana versus the United States without that man who really helped us tell the story of the government's involvement in causing the climate crisis since the early years of the Carter administration and on through. And he wrote a great book called They Knew. So if you haven't checked that out, please do. So a lot of power that comes out of this school. And I also want to thank my former deputy director, Lou Helmuth, who is an alum of this school, and his wife, and then my husband, Steve, who's here, because without the three of them, I wouldn't be standing here today with all the great work over the last 15 years. So lots of thanks to share in this room. All right. So I did found our Children's Trust in order to really elevate the voices of youth and help them claim their climate rights. And I'm really excited to have some young folks in the room today. And anything sort of uncomfortable or disturbing I say about climate change, it's aimed at the adults in the room, especially the older ones. So just know that, and also believe I have so much hope for your future. So I want you to know that as you listen today. All right. So one of the things that inspired me when I was starting our Children's Trust, it was my own children. It was also the work of Dr. James Hansen, who's one of the most incredible climate scientists on the planet and was raising alarm bells in the 1980s and beyond. And then also it was my work as an environmental lawyer. I started my career as a public interest environmental lawyer. I had my own practice for a long time. And I really saw some of the holes in environmental statutory law. And I'll just speak to a couple of them. One is environmental law is a really good tool for playing defense. And so I was able to stop a lot of bad projects and stop polluters from polluting, but I didn't see it as a really effective tool to address the systemic problem of our fossil fuel reliance in the time frame we needed. Also, storytelling is really, really important as litigators. And sometimes environmental law is so complex that we lose the human element in it. And it didn't always give us as lawyers a way to connect with the movements that were growing, including from organizations like 350.org that comes out of Vermont, and all the stories Bill McKibben was trying to tell, but at a time when the media wasn't really covering climate in a human-centric way. And so I think it's so important on climate that the mascot is not the polar bear, but it's the children in our lives, your own children, your grandchildren, your nieces and nephews, because that's what's going to get us to really pay attention. And so our Children's Trust really set out to change the narrative so that people could understand that the ability to breathe clean air and drink pure water, and to gather or grow or hunt your food, or to practice your cultural traditions that are rooted in nature, that those things are fundamental human rights, and that those are things we need to pass down to the young people and our next generation. And that those rights actually root from our founding documents, both at the state and the federal level. And so for founding documents, I mean our constitutions, our Declaration of Independence, the things that make us a democracy. They don't just come from the 1960s and 70s and environmental statutory law. And in fact, the public trust doctrine that Christoph mentioned is an ancient doctrine that comes from Roman times. I think it actually really originates in indigenous cultures. And it is this obligation that government has to care for those things we all share in common and need for our lives. And so just to think about, there is no life without air, right? There is no liberty without water. There is no property rights without land. And so just trying to rethink about our constitutions and what they stand for was one of our really central goals. So when you step into the world of constitutional law and civil rights, you look back to the civil rights movement. You look back to the women's rights movement. You look to the marriage equality movements, because people have done this before. And so the work we're doing is really building on like just the lion's work that has been done before us by so many social justice activists. And the next step is to realize equal justice for young people and for generations to come, and their equal rights. So one thing I've learned, I started as an environmental lawyer, and then I started to think of myself as a human rights lawyer, and now I really think of myself as a children's rights lawyer. And I've worked with some incredible children's rights scholars and law professors across the country, and what they have taught me is that the law centers adults. And so it's one of the things I'll just ask you to carry as we go through this talk together today, that both children's rights law and climate rights law are really in their nascency, and they need a lot of cultivation and growth. And so how do we do that? How do we develop constitutional law? Well, it's through conversations. It's the conversations that lawyers and clients have with judges. It's the conversations we have with legislators and policymakers. It's the conversations we have in churches and in living rooms. And it's conversations we have in academic institutions and really in law schools. And I will tell you where the law evolves the quickest is with young law students and young people, because they can see it so much more clearly than often older people. So when we launched our Children's Trust, it was the Obama administration, and we are in such a different world now. You might notice. And I think, we have this multifaceted strategic attack on our democracy happening on all levels. You just pick up the paper and there's a new thing every day. And the goal is to install more of an autocratic leader and lift up a bunch of oligarchs, right? All at the expense of our democracy. And I think how we address children's climate rights and our dependency on fossil energy will make or break our democracy. And the reason I say that is, in part, it's the life support system. Without climate stability, everything else falls. We can't have a stable anything without climate stability. But also, without young people to carry the torch of democracy forward and believe that it can actually create a just world for them, we lose democracy. And if young people know one thing, it's that there is no justice without climate justice. And so it is critical that we address these issues. So how do we invigorate in our legal system an appreciation for childhood and children's rights? I'm going to share a story of the way we're doing that at our Children's Trust and walk through a couple of our campaigns and our successes and talk about where we're heading. And before I do that, what I would love for especially the older crowd in the room to do is to take a minute, and you can close your eyes if you want, and go back to childhood when you're young and remember a place in nature where you felt joy and you felt safe and you felt held. And if you can conjure up a memory and notice what you may have felt or remember feeling as a child. So I hope you hold some of that as we go through the talk, because I think this problem of the law centering adults is that even cases that are framed as this is a children's case, judges automatically revert to an adult lens and forget that core of what it is to be a child, which is not just a small adult, right? It's a developing human being that's growing and changing. And so for me, I have that place. Like, I remember the snow piles up to my roof line in Colorado Springs, Colorado, where I grew up, and being warm in my snowsuit but cold in my extremities, and then going inside and drinking hot chocolate, and just that total joy of snow. So I love snow. I probably love living here. And today in Colorado Springs, the snowpack is 2 to 8% of historic levels. They're already in drought, and water restrictions are in place. And probably there will be significant fire this summer, right? So these places that we can remember as adults are already so different. And that's some of what is really at stake here. All right. So I went too slow there, and something is wrong with the slides. The font may not have translated, so we'll just go with it. All right, so Lisa Patel is a pediatrician, and she sits on our board, and she says that the single biggest driver of the health of every child born today is climate change. And there are 2 billion children who live on the planet, and there are 2 billion children without political power. Okay, and just to put that into context locally, here in Vermont, you have about 115,000 children under the age of 18, and just a few thousand more than that voted to elect President Trump. So that gives you a perspective of how much political power is not realized by young people, nor do they have the economic power to decide, are we going to burn fossil fuels for energy, or are we going to power everything with wind and the sun? They don't get to make that choice in our system, and they don't get to go to the polls. So remember that as we get further along. We're going to skip some of the bad ones. All right. So we are, Christoph spoke to some of this, we are really focused on bringing the best science into the courtroom in our work. The best science that pro bono services can buy, which turns out is a lot. We have Nobel laureates, we have people like Gus Speth, we have top experts in their field, and the reason we do is because these climate experts and energy experts and doctors and historians, they are aching to have someone in power listen to them. And they are so deeply honored and excited to stand with young people and help validate the stories of what they're experiencing and what the action that they're calling for. All right, so we're going to jump into this case for a minute. But before I talk about Held versus Montana, I want us all just to remember that 15 years ago in 2010, when we started this work, there had not been a single youth-led children's rights climate case filed on the planet. And today, the numbers keep rising, but it's about 90 cases against 50 countries where youth are suing to protect their climate rights. And then there's a lot of state cases that our Children's Trust is bringing. So this is a new, just burgeoning field. There's so much hope, and the young people are starting to really win, and win big. So Held versus State of Montana was our first trial. And we knew if we could get to trial that we could win a case, but governments kept blocking us every step of the way. And their primary arguments were, you know, this is a global problem and we're just a small piece of it. Or everyone's harmed by climate change, therefore no one can bring a case, which is called the generalized grievance theory in law. And the third big argument was, it's not our pollution, it's the fossil fuel industries, it's all of you as consumers, everyone else is causing this problem, not us. And really, it is a government problem because every fossil fuel activity that occurs in our country and in every country is permitted, it's based on R&D the government does, it's subsidized. It is a government-empowered system. You can ask Gus, he'll back me up on that. All right, so in Held v. Montana, it was the first children's constitutional climate trial of its kind. It lasted 7 days. The state could not put on a defense to save its life. And the 16 plaintiffs, here they are. They come from all over the state. They have a variety of injuries. And what was incredible, it was the first time that 12 young people took the stand and were able to tell a judge how they were being harmed. So on the left is Sariel, and she's indigenous. She comes from the Confederated Salish and Kootenai tribes of the Flathead Indian Reservation. And one of her powerful stories was the creation stories that are passed down from the elders to the young in her tradition can only be told when the snow falls and the ground is white at a certain elevation that is a sacred place for their tribe. And so when the snow doesn't fall at that elevation anymore, they can't pass down their creation stories. And it was those deeply personal stories that these plaintiffs told that really illuminated why this is such a catastrophic issue happening and why judges and governments need to step in. Badge, in our work, and for the new lawyers out there, we really try to bring the stories that can touch different people, because you never know where your judge is going to be really captured. And so Badge told stories of hunting and fishing being impacted. Grace told stories of playing soccer in heat and watching glaciers melt and losing glaciers in just her short lifetime in Montana. And then Ricky Held, the first name plaintiff, she's been a rancher her whole life, and they've had cattle die. She's worked in 105-degree temperatures with smoke and fire burning across the river. Their family's economic livelihood was affected and is affected increasingly by climate change. And every single one of the plaintiffs, I think it was one of the most heart-wrenching moments for those of us who live out west. they talked about smoke season. And when I was growing up, there was no smoke season. And now the best part of Montana summer is often covered in smoke. And some of the kids have severe respiratory illnesses. 2 of the youngest boys actually had to leave the state because of the smoke conditions. These were our 10 experts, and they all donated their time. They are climate scientists, energy experts, health experts, indigenous experts, water tower experts, and then an expert on the fossil fuel conduct of the state. So Ann Hedges, who's in the blue sweatshirt on the bottom, she runs an organization and has tracked for decades the state's fossil fuel activities, and she testified they had never once denied a fossil fuel permit. Despite the historical evidence we put on that we found in the Montana Historical Society, that in 1968, the government had a report that said, if we keep burning fossil fuels and carbon dioxide emissions keep going up, it's going to have catastrophic consequences for our state. Right? So it's this disconnect between knowing how bad burning fossil fuels is, but then continuing to do it. And the law we challenged a couple laws, but the thrust of the case was they're permitting all of this fossil fuel activity, and they had a law that said you have to put blinders on, you can't even consider climate change in your decision making. And so that was the fundamental law that the court ultimately held was unconstitutional. One of the key pieces that we established in the case that's important for all climate litigation is really based on the testimony of Dr. Steve Running and this very important Keeling curve. So has everyone seen this curve before? Yeah. So Charles Keeling started measuring CO2 back in the 1950s, and this is, an ongoing measurement taken at Mauna Loa and other places around the world. And by the way, our president wants to cancel the lease for Mauna Loa. I don't know what the status is, but that's the kind of science that's at jeopardy right now. So Dr. Running established and the court found that when we cross this threshold of 350 parts per million, that's where climate stability, we lost it, right? Like up until that point, it was still more CO2 and more heat than humans had ever lived in on the planet, but there was still enough stability in the system. So since the late 80s, when I went to college, we've had climate instability. And so the testimony showed that every ton of carbon dioxide emissions, greenhouse gas pollution, is adding to global warming. And this has been confirmed by the international body that compiles all the climate change science. And the court found that, which was really critical. Oh, that's a bad slide, so we'll stick here for a second. So the other thing that was really important in the case was the medical testimony. I think it's the physicians and the psychiatrists, the pediatricians, pulmonologists, people who help us with that expertise are some of the most powerful experts that we bring forward, because they're really linking not both the pollution from fossil fuel industry and infrastructure that's already occurring like in local communities, but also the broader pollution that then comes from climate change, and the effect of heat on young developing bodies and the increase in infectious disease, that really just this body burden that young people bear their whole lives long. And so that is, for anyone doing environmental work, I just really encourage you to look at the health implications of what you're working on, because it does speak to judges in a really powerful way. All right, so this is Ricky. She's saying that their case was ruled on by Judge Seeley based on the best available science on climate change. Ricky is now in Kenya teaching science, and she wants to go to graduate school to study climate change and glaciology. So after this trial, Judge Seeley issued her findings of fact and her conclusions of law. And I know some of you have studied this case in law school in depth, and I'm not going to go that in depth about it, but I want to highlight a few things. So these are three really important findings. One is that until atmospheric greenhouse gas concentrations are reduced, extreme weather events and other climactic events such as droughts and heat waves will occur more frequently and in greater magnitude, and plaintiffs will be unable to live in clean and healthy lives in Montana. And then again, that every ton of fossil fuel emissions is contributing to global warming and causing constitutional injuries. Right, so just take that in. Every ton of pollution the government continues to allow is causing constitutional injury. So after, and it's a 100+ page document, so she just really walked through all of the evidence we presented. And then we went up to the Montana Supreme Court. And the Montana Supreme Court affirmed her findings, so didn't find that there was anything flawed about her factual analysis. And then they dealt with these questions that I mentioned that governments keep raising. And they said that global emissions don't insulate a state from its own affirmative constitutional obligations. And the state does not have a free pass to pollute the Montana environment just because the rest of the world insists on doing so. So really shut down that argument, which is starting to happen around the world by courts in other countries. And then they also addressed an issue that has been a big hurdle for us, which is redressability. Can the court do anything about this? And the court said yes, plaintiffs can enforce these rights. And declaring that the law is unconstitutional and joining the state from acting in accordance with that law will alleviate that constitutional injury, even if other things are continuing to cause harm. So really, really important redressability ruling. So the plaintiffs had this incredible win, and we just won in the Supreme Court in December. It was a 6-1 decision, and it's really the first of its kind in the world that, thank you, and our plan is to replicate this. And this was, some people are surprised this happened in Montana because it's known to be a red state. And there are some special things about the Montana Constitution that I'll just mention. One is in the early 70s, they had a constitutional convention that young people had a lot of power in. So early 20-somethings were part of this. And they were able to codify the right to a clean and healthful environment in the Montana Constitution. They also codified the right of people under the age of 18 to have full equal rights as adults. So we use both of those provisions. But it's also really important to know we use traditional substantive due process rights. So the right to life, liberty, health, safety, dignity, and the right to equal protection of the law. And the judge found that all of those rights had been violated, not just the right to a clean and healthful environment. And so even for constitutions that don't have that right, these cases are still very viable. And I'm sorry about the text. We have a trial website. One of the beautiful things about this case and this judge, she opened her courtroom to cameras, to video, to the press. And so the entire trial is on film, and it's on our website. You can watch experts testify or plaintiffs testify, and there's a lot of other materials. And so our hope is that law professors will really use this in their classes to help teach students about how to put a constitutional rights case together. There's a lot to learn. So I encourage you to check it out, and even if you're not a lawyer, really interesting testimony in here. Our next trial, you can put this on your calendars, is our Canadian case. So a group of young people sued the federal government in Canada, and this case was modeled a lot after the Juliana versus United States case. This case went up and down through appeals, and we now have a clear path to trial. Nothing can stop it. And this will be a 2-month trial because in Canada, they really take a long time to do things. They have really long hearings and fully vet evidence. So we are in the process of doing discovery and preparing the expert reports right now, and the plaintiffs are getting ready with all of their evidence and testimony. So really exciting to see that case moving forward under the Canadian Charter. All right, Navihine. So this is a different kind of success and really an unexpected one that I honestly couldn't dream of. And it's funny, Professor Mary Wood from the University of Oregon, she has been telling me for 15 years, can't you just get them to settle one of these cases? And we've had a lot of settlement negotiations in different cases over the years, and the governments don't offer up anything. I mean, it's been really a waste of time until this case. So this case against the Hawaii Department of Transportation challenges the whole transportation system in Hawaii. Hawaii is a state that is leading in terms of its laws that require it to get to zero emissions by 2045. They have just incredible laws on their books. They have an incredible constitution, and their transportation emissions were going up. And so we challenged that sector specifically because if you can get a clean mandate for transportation, transportation has to electrify. Everything going into that also has to be clean. So transportation is a really good hook, and to cut off petroleum. In fact, I had someone say to me that if you can totally electrify transportation, and this is why Trump hates EVs, okay? If you can electrify transportation, you cut the fossil fuel industry off at its knees because it makes it the most money you buying gas at the gas station. Petroleum is like their biggest cash cow, okay? So we go after the system, we get all of our experts lined up, all the plaintiffs had depositions taken, all the experts were deposed. We deposed their experts. They were working with a mainland firm in California, big mean firm that has represented Trump a lot. And they were, hardcore going after us. And the state was spending millions and millions of dollars to pay this firm. Until the guy in the green shirt, Director Ed Sniffen of the Department of Transportation, who's Native Hawaiian and has kids, said, I don't want to fight the kids anymore. And he went to Josh Green, Governor Josh Green, who's in the middle with the lay, and Governor Green gave him the green light to meaningfully come to the settlement table. So after weeks of settlement negotiations that shocked me, we had an agreement, and it is the first of its kind in the world. So one of the things that was just absolutely non-negotiable for us was they had to get to zero emissions by 2045, and we needed court supervision, and they agreed to it. So we have a court-ordered settlement agreement. The young plaintiffs are essentially in a marriage with their state for the next 20 years. And we can go to the court. We have a process if there's non-compliance with the agreement that we'll go through. But ultimately, we have the court to back us, which is really important. And one of the things they had to do in Hawaii, and I think this is true in many states, is when you enter into a settlement agreement involving children, the court has to find that the agreement is in the best interests of the child. And so the court did that here and found that zero emissions in a transportation sector were in the best interests of a child, which we love. And it's really the first time that you have all three branches of government in any government that I'm aware of really working together, which is the best of what democracy has to offer. So there's a lot of components to the settlement agreement. It's on our website. You can check it out. And I think for some of the law students who are going to friendly blue attorney general's offices, there is such a thing as friendly litigation that can result in this type of settlement agreement that really gives the government an ability to hold itself accountable and accountable to its youth. And this used to be a thing when I was practicing law back in the day. We would bring litigation that we knew a friendly federal administration would want, because it would help them do the right thing under the law, and we could settle cases. That's changed a lot, but I think at the state level, it's still really possible. So anyone who has connections to attorney general's offices who really want to get something done, it's a really effective way to do it. So they have to hit certain benchmarks. And this is about ground transportation. It's also about inter-island sea and marine, sea and air transportation, and getting their ports set up for the long-haul transition. And there's a lot of other really cool stuff that you should check out. But the Youth Advisory Council is one of our favorite pieces. So some of the plaintiffs and then other youth from across the island sit on this council, and it will rotate to new youth over the course of the 20 years. The Department of Transportation has to report to these youth on a quarterly basis. Right now they're meeting monthly, and they get to help shape the policy in a really meaningful way. So not just as sort of an honorary thing, but they're actually in conversation. And one of the new leadership positions that oversees the settlement agreement, in the first meeting with, I think there were hundreds of Department of Transportation staff and the plaintiffs, she stood up and said, "These are our new bosses." And so there's a deep appreciation for the keiki, which is children in Hawaii, and they're really embodying that and living up to it in the settlement agreement. So those are some of the amazing plaintiffs in that case who are really doing hard work. All right, so I'm just going to say a few words about Juliana and then wrap it up so we have time for questions. It's been an honor of a lifetime to represent these plaintiffs. They were in litigation against the United States government, the country most responsible for the climate crisis, for 10 years, just trying to get to trial. And this case is a children's Fifth Amendment case about their right to life, liberty, personal security, and access to public trust resources like air and water, ocean, and shorelines. And, you know, as you can read in Gus's book, the United States knew since really the 50s, but by 1965, there was a White House report from Lyndon B. Johnson about the fact that atmospheric carbon dioxide levels would cause climate change and really be deleterious for human beings even by the year 2000. And their science was really quite good even back in the 60s in terms of the general impacts that they saw coming. And despite that, in a nonpartisan way, really, across Democratic and Republican administrations, fossil fuel production and use in the United States just went up. And I don't have the charts in here, but even today, we are the largest oil and gas producer in the world. Largest oil and gas producer in the world. So even though the Biden administration made efforts to increase a transition in our electricity sectors and in our transportation sectors, we were still producing so much, even if it was being exported. So I'm not going to walk through this wild timeline, but this is the timeline. It's the District Court, Supreme Court, and Ninth Circuit. And over 10 years, this was the hardest fought case I know of in U.S. history. They made 13 attempts to dismiss our case. They did 7 petitions for writ of mandamus, which most of you don't know what that means. I didn't know what it meant until they served one on us. It's a rarely used tool. I think there were 2 petitions for writ of mandamus during the entire Obama administration in 2 different cases. We had 7 just in this case. And I want to show you these young people. So these are the Brown versus Board of Education plaintiffs in the Kansas case. And how long do you think it took them to get to trial? Then Anyone know? 4 months. And what is so striking to me about that is, that there were no standing challenges, no motions to dismiss. They went to federal court to say segregated schools are unconstitutional. And what's wild is Plessy versus Ferguson was the law of the land. The Supreme Court had already said segregation is okay, folks. So not only were they bringing a case where they'd have to overturn Supreme Court precedent, but they were bringing forward sort of novel factual claims about children being harmed and bringing forward social science evidence about the psychological damage to Black children, right, from segregation. And it just shows you how out of whack our legal system is right now, right? They were given the opportunity to overturn Plessy versus Ferguson. And then in 1954, for those of you who haven't learned this yet in school, they won in the US Supreme Court 9-0, right? Incredible. So one of the things that Juliana accomplished, it had so many successes along the way, even though it ultimately lost. And one was this November 2016 ruling, days after President Trump was elected to the first term, where Judge Ann Aiken said, "I have no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society." And that was the first time a judge anywhere in the world had said that. And it inspired courts around the world to really start establishing climate rights. And the Ninth Circuit Court of Appeals that shut us down the first times told the kids to go to the polls. Okay, literally told kids to go to the polls. So remember what I said in the beginning, right? And the dissent said, fundamental rights may not be submitted to vote. They depend on the outcome of no elections. They are beyond the reach of majorities and officials. So anytime you hear someone say, well, isn't this a policy issue? Isn't this a political issue? Shouldn't people just go vote? Remember, children can't, and when fundamental rights to life are at stake, they deserve more consideration than that. So I'm gonna just skip over all the bad stuff because we don't need to talk about the Trump stuff. We have plans there too, so we'll have new litigation filed very shortly. But I want to end with, this story. So a lot of people ask me, how do I stay hopeful when the hill seems so big? It's one of the first questions I get. So someone was probably going to ask me that question. And there's all the answers about like self-care, and I love climbing mountains and all of that. But this is Claudette Colvin, and she, before Rosa Parks, she took a seat on a bus displacing a white person. And she was arrested, and she became one of 4 plaintiffs in the Browder versus Gale litigation that went up to the Supreme Court, and it was the ruling that said segregation on buses is unconstitutional. She testified in court at the age of 16. And in her elder years, Ms. Colvin said, "History had me glued to the seat. It felt as if Harriet Tubman's hand was pushing me down on the one shoulder and Sojourner Truth's hand was pushing me down on the other. Learning about those 2 women gave me the courage to remain seated that day." Right? So the youth we work with, they feel the hand of history on their shoulder, and they also feel the hand of the future on their shoulder. They see beyond their own time, and they see a world of intergenerational justice and justice for all, no matter who you are. So I think this is about the present, it's about our lineage to the past, it's about our legacy for the future, and it's just about standing up, right? And remembering, like, people have done such hard work before us. So that's what I do. And I think our judges right now have such a critical role. So I'm not going to read this, but Judge Aiken wrote this, and it's so important right now that judges and lawyers stand up. And please center children's rights in your work. If you are a law professor, if you are a lawyer, if you're a law student, remember to think about children in every area of law that you're learning. Because if we're not bringing their cases and stories forward, then we're not going to address the fundamental problems in our society, including climate change. So, a message to leave all of you young students with, all of the law students and the graduates. In 2010, when I launched our Children's Trust, everyone said I couldn't do it. They said it would never work, there would never be these constitutional rights, and there were very few lawyers and law professors who believed in it, including people, at the school. And so don't let them tell you can't do it. Because imagine where we would be today right now in the climate movement if we didn't know Kelsey Juliana or Vic Barrett or Ricky Held or Navahine and all of these names who will go down in history and be read by children in the books for decades and decades to come. And thank you for having me. I appreciate it.
We have about 10 minutes to have a few questions. Thank you so much, Julia. That was wonderful. I would like to use the person with the microphone privilege of allowing any questions from folks who are graduating law students or younger. Any hands from that group? Have a question?
Thank you so much. Hi, thank you for being here. That was very inspirational. I appreciate you coming out. I guess my question is, as we're moving into this time where the administration is ignoring Supreme Court orders, like if y'all get the big guarantee and that happens, any contingency plan for that?
So one thing is about our work is that we are always working at different levels. So at the state level, at the federal level, and then we're working globally. And state Supreme Court decisions should never go up to the U.S. Supreme Court. I think, there are sometimes efforts to do that. But what happens at the state level can be really protected in many ways. And of course, what the president is doing will affect what states are able to do on climate, no doubt. And yeah, I think there's a chance we could win in a new case against Trump that we will file, and it could get overturned by the Supreme Court, or we could win some piece and Trump could ignore it. And that is not a reason not to do it, right? And oftentimes in law, people lose or something happens and then it takes the next time, but you've laid the groundwork. And I think sometimes what people forget, lawyers forget, is if we aren't educating judges, like judges don't know everything, right? They only know and they learn about facts and circumstances and stories that are brought to them. And so we have to start educating even the U.S. Supreme Court, because even Justice Sotomayor, who I love, does not understand the difference between the ozone layer and climate change. In an oral argument, she confused the two. And so, there's a lack of education that we need to start educating people. So amicus briefs to the Supreme Court, cases that are really well developed that can go up there. We should not be afraid to lose, because we won't win sometimes until we lose. Look at what the right did on Roe v. Wade to get to Dobbs. It was a 50-year campaign. And we don't have 50 years, but we need to be pushing on every front. And I do think I still believe in democracy, and I still believe there's enough checks in the system. There's so much more people who hold power today, right? I mean, women hold power, people hold power who can step up. So I have faith. Yeah.
Any other questions? Oh, wonderful.
That is amazing. My question is, what should kids do about it?
Such a good question. So I think there's so much that you can do. And what I tell everybody, whether it's a young person or an old person, is we all bring our special talents and skills to the world. And it's really listening to, like, what am I good at and what do I love and how can I use that in combination to make a difference, right? So if you're an artist or you love to make music or you love to write, you can use any of those tools to make a difference, right? So the way you do it, the medium, the things you use to make a difference are going to be based on who you are. And then some core things that are important is, talk to your friends and your family and your teachers and start talking about how, like, I have constitutional climate rights. And did you know that children really have the right to equal protection under the law? And asking people to help you learn about what your Constitution can do for you, both at your state level and at the United States, and get involved in those conversations. And make adults help you, right? Like that's the thing. A lot of people will lift up the youth I represent and put them on a pedestal and say, thank you so much, you're going to save us. And they hate that because what helps young people the most is having adults working with them and supporting them to make a change in the world. So get your adults involved.
I have a question.
You do for the online folks.
I was wondering if you would talk a little bit more about the enforcement mechanisms you like when you win a case. I know you talked about it a little bit with the Hawaii case, but how do you keep governments and big corporations coming to the table? I know that a lot of our frustrations in environmental law stem from laws that don't really have any teeth in the environmental law sphere. So I hope you can talk a little bit more about enforcement mechanisms that you think are actually working.
Yeah, I mean, in our cases, it varies. So Hawaii is an example where there is a good partnership, and when they're going astray, at this point in time, they're really working with us. They hired a consultant that wasn't doing such a great job with their greenhouse gas reduction plan, and they asked us to come in and help. So it's great when you can have partners in government that do that. That's not always possible. Montana, the legislature is trying to pass laws to undermine the court win, so they're doing everything they can to keep fossil fuels in play. So there it's going to take more litigation and follow-up enforcement in the legal realm and in court, frankly. But judges have a lot of power, I think we're going to get to a point where there will be contempt hearings. Judges can fine people who don't comply. They can put people in jail who don't comply. So there's a lot of enforcement that can be done in the litigation and court context. And beyond that, I think one of the disservices to environmental law specifically, if you're talking about that, is to put everything in the procedural context. I think there's so much great substance in our environmental statutory laws, and a lot of environmental lawyers' instinct is to go to the procedure. and the process, when really what we need is substantive enforcement. And process delays, it creates all this regulatory gridlock. It's not even good for the business community, right? It slows everything down. Like, I think we need to build more substance and teeth into the policies we have, in addition to using the courts in that way. So every time someone wants to just bring a process case, look for a substantive hook. Yep.
Question, if I can.
Hi.
Hi.
So, what are your strategies for having meaningful conversations with folks who don't necessarily believe the science behind climate change?
Yeah, that's a good question. So this actually comes from someone else, and I was just in conversation with him. His name is Spencer Glendon, and he has an organization called Probable Futures. And he's really worked a lot to communicate what's happening with climate change to insurance companies and banks and, a lot of people in the financial world. And what he says is, he'll meet with someone and say, okay, so you don't believe in the climate science, like, tell me what you do believe. Like, do you believe everything's just gonna stay the same? And what's your evidence for that? Because they're believing in something, right? And they're believing that there is no risk or whatever. And so, most people know something's changing. And so I think sort of engaging, well, what is your belief? If it's not climate change, what is it? And is it you're just going to really bet on that everything's stable and is going to be fine? Most people have some interest that's being affected. So maybe approaching it from a different angle. Outright climate deniers who just don't want to have sort of kind of far-right MAGA people who just don't want to have a conversation about it, I don't waste my time there. Yep. Thanks, everyone. Thanks for coming.
Thanks so much, Julia.